In this lecture, we'll be covering chapters 34, 35, and 36. Chapter 34, Nature of a Corporation. The different classifications and kinds of corporations are public, private, quasi-public, not-for-profit, profit, stock, close, subchapter S, foreign, domestic, and alien corporations. To form a corporation, incorporation papers must be prepared, a registration statement may need to be filed, stock must be sold, and contracts entered into for the benefit of the proposed corporation. A promoter is potentially liable for contracts made for the benefit of the corporation unless there is a contract provision excluding personal liability. In addition to express powers set out in its charter, a corporation also has implied powers and incidental powers. If a corporation engages in frequent or serious ultra vires acts, the state may cancel its charter. Corporations may be classified as follows. Public corporations formed to carry out some governmental function. Examples would be a city, state university, or public hospital. Private corporations formed by private individuals to perform some non-governmental function. They are classified as not-for-profit and profit corporations. Corporations may also be classified as domestic or foreign. Preliminary work for the formation of a corporation includes preparation of incorporation papers, filing of the registration statement, if necessary, with the Security and Exchange Commission, and the appropriate state officials, and selling of stock. The promoter may avoid personal liability on contracts made for the benefit of the corporation by including a provision in the contract that there is no personal liability if the corporation does not adopt the contract or after the corporation adopts the contract. The corporation may or may not pay the expenses of the promoter in the organization of the corporation. It is customary for the corporation, after it comes into existence, to reimburse the promoter for all expenses necessary in forming the corporation. When a corporation is new and is about to be formed, contracts to buy its stock will usually be made in advance of the actual incorporation by means of subscriptions. The written document setting forth the facts prescribed by law for the issuance of a charter and asserting that the corporation has complied with these legal requirements is the Articles of Incorporation. The powers that the corporation has are either express, incidental, or implied. Incidental powers of a corporation include the right to have a corporate name, have a continuous existence, have property rights, make bylaws and regulations, engage in legal actions, and have a corporate seal. Implied powers of a corporation include the right to borrow money and contract debts, make, endorse, and accept negotiable instruments, and mortgage or lease its property. An ultra vires contract is one entered into by a corporation that is not authorized by any of its powers, express, incidental, or implied. Let's go over our Chapter 34 review questions. Question 1, explain how a not-for-profit corporation differs from a for-profit corporation. Because a not-for-profit corporation is not organized for profit, It does not distribute income or profits to members, officers, or directors, and usually does not issue stock. Question 2. How is a tax savings achieved when a corporation is designated a subchapter S corporation? There is a tax savings when a corporation is designated a subchapter S corporation because the corporation's profits are not taxed twice, once when shown on a corporate tax return and a second time when shown as income from the corporation to the owners on their personal tax returns. Question 3. Is a corporation automatically a party to contracts made by promoters? A corporation is not automatically a party to contracts made by promoters. After the corporation is organized, it will ordinarily approve or adopt the contracts made by promoters. Such approval can be express or implied. Question 4. Is a subscriber to stock in a corporation to be formed bound by a subscription agreement? Since a subscription agreement signed by a subscriber to stock in a corporation to be formed is an offer to buy, it may be revoked any time prior to acceptance, and the corporation cannot accept until the state issues its charter. Question 5. What is a corporation's articles of incorporation and what is their importance? The Articles of Incorporation is a written document setting forth the facts prescribed by law for issuance of a certificate of incorporation and asserting the corporation has complied with legal requirements. Question 6. What does the law frequently require to be included in a corporation's name? The law frequently requires a corporation's name to include the word corporation or incorporated, an abbreviation thereof, or other indication of corporate status. Question 7. How long does the existence of a corporation continue? The existence of a corporation continues for the period for which the states grant the charter, which period can be perpetual. Question 8. What powers does a corporation have in addition to incidental or express powers? In addition to incidental or express powers, a corporation has the implied power to do all acts reasonably necessary for carrying out the purpose for which the corporation was formed. Chapter 35, Ownership of a Corporation. The capital stock of a corporation is the declared money value of its outstanding stock. Stock can be common or preferred, and preferred as to assets or preferred as to dividends. Stocks can also be par value or no par value stock, treasury stock, or watered stock. A stock right is called a stock option. Dividends are the profits of a corporation distributed to the stockholders. They are declared by the board of directors and may be paid in cash, stock, or other property. Blue sky laws regulate the sale of securities in intrastate transactions. The Federal Securities Act of 1933 regulates the sale of securities in interstate commerce. The Federal Securities Exchange Act of 1934 regulates the activities of securities, exchanges, brokers, and dealers of securities. The Securities Protection Act of 1970 provides protection for investors when their stockbrokers or investment houses have financial difficulty. capital stock of a corporation is the amount authorized by the Articles of Incorporation. Ownership in a corporation is evidenced by the title to one or more shares of stock. A certificate of stock shows the amount of ownership, that is, the number of shares owned. It also indicates the manner in which the stock may be transferred to another party. The two principal classes of stock are common stock and preferred stock. Stock to which a face value has been assigned is par value stock. Stock to which no face value has been assigned is no par value stock. Common stock may be either par value or no par value. Treasury stock is stock a corporation has issued and then reacquired. Watered stock is stock that has been issued as fully paid when it has been paid for by services or property at an inflated value. Stock options give the holder of the option the privilege of buying a given number of shares of stock at a fixed price at some future date. If the stock's selling price rises above the option price, the holder can exercise the option and sell for a profit. If the price goes down, the holder merely refrains from exercising the option. Dividends are the profits that have been made available for distribution to the stockholders. Blue sky laws have been passed in most states to prevent fraud through the sale of worthless stock. The Federal Securities Act of 1933 was passed by Congress to regulate the sale of securities in interstate commerce. Every corporation offering a new issue of stock to the public in an amount in excess of $5 million must provide every subscriber a prospectus. The prospectus must set forth the nature of the corporation, the type or types of stock to be issued, the selling price, and other pertinent information. The Federal Securities Exchange Act of 1934 regulates the sale of securities in the security exchange and over-the-counter markets. The Securities Investor Protection Act of 1970 is designed to aid certain customers of securities, brokers and dealers who experience financial difficulty. Let's go over our Chapter 35 review questions. Question 1. How may the amount of capital stock authorized for a corporation be altered? The amount of capital stock authorized for a corporation may be altered with the consent of the state and a majority of the stockholders. Question 2. If a corporation does not issue certificates of stock, how is ownership of stock shown? If a corporation does not issue certificates of stock ownership, ownership is shown on the corporation's corporate record book. Question 3. Why do corporations with a small number of stockholders frequently have restrictions on the transfer of its stock? Corporations with a small number of stockholders frequently have restrictions on the transfer of its stock in order to allow the current stockholders to control the management of the corporation. Question 4. What preference might be granted to preferred stockholders? Preferred stockholders might have a preference pertaining to the division of dividends, to the division of assets upon dissolution, or both of these. Question 5. What does it mean if stock is 7% non-participating? If stock is 7% non-participating, it means that 7% is the maximum to which the preferred stockholders would be entitled, no matter how much the corporation earned. Question 6. Must the purchaser of par value stock always pay a price in money, property, or services equal to the par value of the stock? A purchaser of par value stock from a shareholder will ordinarily pay a price equal to the market price, which may be more or less than the par value of the stock. Question 7. Is it always possible to easily determine whether stock has been watered? It is not always possible to easily determine whether stock has been watered if assets such as patents, trademarks, blueprints, or other similar assets are used to purchase stock, since the value of such assets might be extremely difficult to determine. Question 8. Why would management officials of a corporation find stock options to be attractive? Management officials of a corporation would find a stock option to be attractive if the market value of the stock rises, because it could be possible to make a capital gain by buying the stock. The income tax on capital gain may be considerably less than that on other income. Question 9. Can a cash dividend be rescinded by a corporation? Once a cash dividend has been declared by the directors of a corporation, it cannot later be rescinded because it has become a liability of the corporation. Question 10. Why must insiders of a corporation disclose their trading? Insiders must disclose their trading because the corporation or its stockholders suing on behalf of the corporation may recover any profits made by an insider in connection with the purchase and sale of the corporation's securities within a 6-month period. Chapter 36, Management and Dissolution of a Corporation. The board of directors and officers manage a corporation. The directors select the officers, who are the chief agents of the corporation. The stockholders control management by electing the board of directors. Theoretically, if the directors do not carry out the will of the stockholders can elect a new board. Stockholders have the right to receive a stock certificate, attend corporate meetings and vote, receive dividends when declared, transfer stock, subscribe for new shares, inspect the corporate books, and share in the assets of the corporation on dissolution. The powers of directors are to manage and direct the corporation and to perform any legal act reasonably necessary to achieve the purpose of the corporation, as long as this power is not expressly limited. The directors have the responsibility of establishing policies that will achieve the purpose of the corporation, selecting executives to carry out these policies, and supervising these executives to see that they effectively execute the policies. The officers have the power to act on behalf of the corporation in carrying out the board of directors' policies. Officers are responsible for torts or crimes they commit, even when they act for the corporation in a corporate capacity. A corporation is dissolved by paying all its debts, distributing all remaining assets to the stockholders, and surrendering its articles of incorporation. It is combined by means of a merger that results in one corporation being absorbed into the other. A corporation can also be combined by means of a consolidation when two corporations combine to form a new corporation. stockholders elect a board of directors that selects officers and appoints other agents to operate the corporate business. The stockholders meet at the place and time specified in the Articles of Incorporation or bylaws to conduct the business devolving upon the stockholders. The board of directors may call special meetings when necessary or desirable. At a stockholders meeting, a quorum must be present either in person or by proxy. The right of a stockholder to vote is the most important right because this is the only way in which any control over the investment can be exercised. The right to vote is controlled by state corporation laws. Every stockholder has one vote for each share of voting stock held. The stockholders representing 51% of the stock present can elect the board of directors. By cumulative voting, the minority stockholders may elect a minority of the board of directors. Under voting trust, stockholders transfer their voting privileges to a trustee. An absent stockholder may vote by proxy. A stockholder possesses the following rights: to receive a properly executed certificate of stock ownership, to attend corporate meetings and to vote unless the right to vote has been given up by agreement, to receive a proportionate share of the profits when profits are distributed as dividends, to sell and transfer shares of stock, to subscribe for new shares in proportion to the shares owned when the corporation issues new stock, to inspect corporate books in the absence of a statute to the contrary, and to share pro rata in assets remaining after all obligations of the company have been paid when the corporation is dissolved. The governing body of a corporation is the board of directors. The directors have the following powers and duties. Powers granted to them by law, by the Articles of Incorporation, and by the bylaws, and duty to establish all major policies of the corporation. Directors and officers of all corporations have potential liability for actions taken as a result of their positions. Directors can be liable for corporate losses or wrongful actions. The Sarbanes-Oxley Act requires greater financial disclosure from publicly held corporations and makes chief executive officers and chief financial officers responsible for that disclosure. A corporation may be dissolved by forfeiture or abuse of the corporate charter, violation of state laws, fraud in the procurement of the charter, failure to pay specified taxes for a specified number of years. When a corporation dissolves, its existence is terminated for all purposes except to wind up its business. Let's go over our chapter review questions for Chapter 36. Question 1. Explain how a corporation can perform business transactions as an artificial being. As an artificial being, a corporation can perform business transactions only through actual people acting as agents. The directors of the corporation constitute agents of the corporation. Question 2. Does the stockholder who owns 49% of the common stock of a corporation have a greater right to work for or direct the running of the corporation? No. A stockholder who owns 49% of the common stock of a corporation has no more right to work for or take a direct part in running the corporation than another stockholder or even a stranger would have. Question 3. In what way do stockholders' meetings act as a check on the board of directors? Stockholders' meeting act as a check on the board of directors because if the directors do not carry out the will of the stockholders, they can elect a new board that will carry out the stockholders' wishes. Question 4. What is normally a quorum and how is it determined? A quorum is normally a majority of the outstanding stock, and this is set in statute, bylaws, or the articles of incorporation. Question 5. What is a stockholder's most important right, and why is it the most important right? A stockholder's most important right to vote is the most important right because only in this way can a stockholder exercise any control over investment in the corporation. Question 6. Explain how cumulative voting works. When there is cumulative voting for directors, a stockholder is allowed to cast as many votes in the aggregate for any one or more directors as equal to the number of shares owned multiplied by the number of directors to be elected. Question 7. May the management of a corporation legally solicit proxies for candidates selected by the board of directors? The management of a corporation may legally solicit proxies for candidates selected by the board of directors. However, the board must disclose the proposals fairly by disclosing all material facts. Question 8. What happens if a stockholder signs more than one proxy? If a stockholder signs more than one proxy, the proxy having the later date would be effective. Question 9. Under what circumstances may a director be held liable for an act when there is no evidence of bad faith or negligence? A director may be held liable for an act when there is no evidence of bad faith or negligence, either because the act is illegal or because bad faith is presumed. Question 10. How does a corporation complete its dissolution? A corporation completes its dissolution by paying all its debts, distributing all remaining assets to the stockholders, and surrendering its articles of incorporation. Email me the answer to question 10 of chapter 36.